Hi, my name is Aslam Moolla and I am a registered attorney. In today's video, I'm going to be talking about what can invalidate a will in South African law. There are a few basic requirements when it comes to wills in South African law. Number one, the person must be of a sufficient age. Any person who is over the age of 16 can make a will. If you are under the age of 16, you cannot legally make a will. The second requirement is mental capacity. This means that a person must be of sound and sober mind in order to make a will. In other words, if the person does not have the mental capacity to sign a legally valid document, or they were intoxicated at the time, the will be invalid. Other aspects that can affect a will are duress, when someone is forced to sign a document. Think about someone on their deathbed, for instance, and the relatives come by and say, sign this before you die. Maybe they haven't read the document, they haven't considered their actions. If you have witnesses to that, you can have that document invalidated. The other one is undue influence, when too much of pressure is imposed on some person, and mistake. If the person who signed the document, which we call the testator, didn't realize he was signing a will, that will not be regarded as a valid will. So in summary, there are some aspects that can invalidate a will. For example, age, capacity, duress, or mistake. Bear these things in mind if you are challenging the validity of a will. If you need help in your situation, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.